Hello everyone, how are you, my level 1-1? I bestow upon you a serendipitous and euphoric evening. My name is Tapiwa Mafundu, and I'm a legal luminary and a politician. So I'm going to take you through the question you were assigned by your lecturer, which is the significance of section 192 of the Zimbabwean Constitution. So I'm going to do just a synopsis of the question. I'm not going to give you the whole detail which is required, but I'm going to give you what is required for you to successfully respond or answer the question you were assigned. So we are going to start by reading the question. I'm not going to say it verbatim, but the question requires you to critique the significance of section 192 of the Zimbabwean Constitution, Amendment 20 of 2013, in the development of the Zimbabwean legal system. So you should highlight keywords in the question. The first keyword is critique. You should know what is to critique. In this instance, as you shall see, to critique is not to criticize, as the word implies, or the literal meaning of the word critique. To critique is to give your own comment on what you think is the significance of section 192 in the development of the Zimbabwean legal system. Yes, as provisioned under section 192 of the Zimbabwean Constitution, Amendment 20 of 2013. Significance, you should also understand the meaning of significance. Significance might have synonyms like importance, or how useful is section 192 of the Zimbabwean Constitution in the development of the Zimbabwean legal system. Okay, you should also be aware of the definition of a legal system, especially the word system. A system is something which is well structured, which is supposed to work in a systematic way. Like we have several forms of my systems, the digestive system and the reproductive system, you should know. But here we are dealing with a legal system, a system which is consisting of the courts, the legislature, the executive, as we shall discuss during the course of the discussion. Okay, so the question says, critique the significance of section 192 of the Zimbabwean Constitution in the development of the Zimbabwean legal system. We should first read out the provisions of section 192 of the Zimbabwean Constitution, Amendment 20 of 2013. I don't have a constitution here, but section 192 of the Zimbabwean Constitution says that the law to be administered in Zimbabwe is the law that was applied at the Cape of Good Hope as at 10 June 1891, after the British High Commissioner proclamation that the law that should be administered in Southern Africa is the law that was applicable at the Cape of Good Hope in 1891 as at 10 June. Okay, you might not understand where I'm taking all this information. Let me take you on a historical background of how the proclamation came to be. So before that, let me first finish the provisions of section 192. The provisions say the law that should be applicable in Zimbabwe is the law that was applied at the Cape of Good Hope on the effective date. So the effective date which is being referred is 10 June 1891. Okay, I'm going to tell you the significance of 10 June 1891. So what happened is, let me take you back to 1652. In 1652, there was a man called Jan van Riebeck. He was from Netherlands. By the time Netherlands was still separate from Holland, it was specifically Holland where he came from. He was a Dutch. So he signed a contract in which he was going to come to South Africa to establish a refreshment site at the Cape of Good Hope which is now Cape Town. I think you all know Cape Town, the present day Cape Town. So Cape Town is located at the coast. It's at the coast. So when Jan van Riebeeck came to South Africa in 1852 to land at the Cape of Good Hope, he wanted to establish a refreshment center whereby he was going to trade items like pure water, fresh water, vegetables, fruits, and he was also going to offer medication to sailors, Indian sailors, because the Cape is at the coast, so ships would want a refreshment center for taking refreshments and taking rest. So he signed a contract in which he was going to establish a refreshment center there. It was called the Cape of Good Hope. That was 1652. But the terms of the contract was that he was not supposed to colonize the territory. The territory was occupied by the San and the Khoikhoi. So when he came, he was engaged in a war with the locals, I mean the San and the Khoikhoi, and he displaced them there. There was a war there, and the San were defeated like always. So I want to focus on the laws, how the Roman Dutch laws came to be applied at the Cape of Good Hope. So the laws that were applied in Holland, where Jan van Riebeeck came from, were mainly Dutch laws fused with Roman laws. Roman laws started during the time of Constantine, during 52 AD, during the Justinian period, whereby Roman laws were formulated by people who were called glossators. So Roman law was very appealing. Rome is now the present day Italy, but by the time it was Rome. So Roman laws were very scientific, they were written down and they were easy to access. So these were the laws which were being applied in Netherlands. So when Jan van Riebeeck came to South Africa, he brought with him Roman laws fused with the Dutch laws. That was when the word Roman Dutch law was coined, through a combination of Rome and Dutch laws. So when he came, he brought with him judges and legal experts who helped him in the implementation of the laws. So when he came to South Africa at the Cape of Good Hope, the locals, the San people, were very uncivilized, that they had no laws which were being used in the area. Those people were very illiterate. I mean, look at the dates, that's 1652. If you are a person who studied history or with an interest in history, you will see that by 1652, the Zulus in South Africa now and the Xhosa were not present in South Africa. If you study the history of Southern Africa, you will see that people in Southern Africa migrated from the north to the south, but the people who occupied the territory in the 16th century were mainly the San and the Khoikhoi, which were mainly nomadic. So when the Dutch came to the Cape of Good Hope, they established a refreshment center as according to the contract, but they came with their laws, Roman Dutch laws, which they applied at the Cape of Good Hope. So fast forward to 1795, the whites came, the English people, they engaged in a naval war. Remember I said it's located at the coast. So they engaged in a war with the Dutch, which ended in around 1795, and the Dutch were defeated. So when the whites came and when they conquered the Dutch, they had with them English common laws. So when the whites came, they did not do away with the Roman Dutch laws which were being applied by the Dutch at the Cape of Good Hope. They fused those Roman laws and Dutch laws with their own English common laws. This is because although Roman Dutch laws were very appealing in all other aspects, they were not very strong when it comes to commercial when it comes to commercial side, the laws did not address the contractual side of laws or commercial side of laws, although generally the laws were very appealing. So the whites, what they did was that they imported judges from England, and they also incorporated Dutch judges which came with Jan van Riebeeck, to make sure that there was proper implementation of Roman Dutch laws and English laws. So English common laws were mainly commercial, and Roman Dutch laws addressed other aspects like delict and so on, as we shall discuss. So when the English colonized the Dutch at the Cape of Good Hope, the Cape of Good Hope was now called the Cape Colony of Good Hope, after it was now under the leadership or the rule of the whites. So I want to trace how the laws came to be applied in Zimbabwe. So you know that after South Africa was colonized, Zimbabwe was considered as a second land. I mean, Cecil John Rhodes established a company called British South Africa Company. So the British South Africa Company developed interests in Zimbabwe because Zimbabwe was considered as a second land in terms of minerals. So the British came, and that is when the Rat Concession was signed, and Lobengula, the king of the Ndebele, gave exclusive mining rights to the British South Africa Company, which later on colonized Zimbabwe under the leadership of Cecil John Rhodes, who was a businessman. So when Zimbabwe was colonized, we were applying customary laws. Customary laws are the laws which were being applied by the chiefs, by the kings and the headmen. Customary laws are the laws which were applied by the locals. You understand? So when the British came in Zimbabwe and colonized Zimbabwe, although they wanted to use our own laws, they had nowhere to reference our laws from. So they ended up using their own English laws together with the Roman Dutch laws, which they had inherited from the Dutch, which they had colonized or defeated during the Anglo-Dutch War. So the laws which were applied in Zimbabwe were mainly Roman Dutch law and English laws, because the local customary laws were not written anywhere, so the whites had nowhere to reference. Another factor is that the language barrier made sure that there was no communication of the laws. Like the whites had no one to consult on the local laws, so by default English Roman Dutch laws became to be applied in Zimbabwe. So I want to take you to the significance of section 192 of the Zimbabwean Constitution. So on the 10th of June 1891, the British High Commissioner, who was responsible for the colonization of Southern Rhodesia will include Nyasaland, Northern Rhodesia and Zimbabwe, which was formerly Rhodesia by the time. So the British proclamation by the High Commissioner was that the laws which should be applied in Zimbabwe are the laws which were applied at the Cape of Good Hope as at 10 June 1891. So you see, section 192 of the Zimbabwean Constitution, when we are talking about the significance of the section, let me read to you. I think I found three significances of the section. Section 192 says, the law which should be applied in Zimbabwe is the law which was applied on the effective date as subsequently modified. By modification, we mean as subsequently amended. So the significance of section 192 is that it is the official acknowledgement. You should note this down. Section 192 is significant because it is the official acknowledgement of the real existence and the applicability of common law in Zimbabwe. I shall take you on what we call common law in Zimbabwe. Then another significance of section 192, you shall develop these points I am saying to you. I am not going to give you the whole detail. So another point is that section 192 states clearly the laws which should be applied in Zimbabwe. Then another significance is that it helps us trace the development of our legal system. I mean the historical development of our legal system in Zimbabwe. Okay, what we call common law is the body of law that is universally applied to Zimbabweans without regard of race, color, or skin, or whatever factor which might want to discriminate. If you were taught in introduction to law, you were told that the laws should be applied in a universal manner. Laws should be applied in an equal manner. Laws should not be discriminatory. So common law is unwritten law which is applied to everyone. Antiga. So that is the significance of section 192. But you should link this significance to the historical development of the Zimbabwean legal system. So the key word here is development. When something is development, it is said to be undergoing change, either positive change or negative change, but development is a change which happens over time. It depends whether that change is positive or it's negative, but normally we expect a positive change. So the development of the Zimbabwean legal system can only be traced through historical channels. That's why I took you back to 1652. So I was now talking about the colonization of Zimbabwe and how Roman Dutch laws came to be applied in Zimbabwe. The laws came to be applied in Zimbabwe through colonization. That's how Roman Dutch laws came to be applied in Zimbabwe. So section 192 is of significance as it officializes the application of Roman Dutch law in Zimbabwe. You shall be taught in detail when you are now doing Roman Dutch law as a module in statutory interpretation. So when Zimbabwe was colonized, the laws that were applicable were Roman Dutch laws together with English laws. But the British proclamation of 10 June 1891, which is cited on section 192 of the Zimbabwean Constitution, did not allow the colonizers to do away with the local laws. The British proclamation of 10 June 1891, which is referred to as the effective date proclamation, allowed the whites or the colonizers to use local laws, but these laws were not incorporated into general law. I mean, kuti, although Roman laws were there, English laws were there, customary laws were also allowed to be referred to. That's why customary laws were still being applied under customary law courts. Even in the present day, customary laws are still being applied under the customary law courts, because below the magistrates courts we have the customary law courts. So the British proclamation of 10 June 1891 allowed the colonizers or the settlers to use local laws, but they did not allow the laws to be incorporated into the general laws. General laws, I mean the common law, which is Roman Dutch law fused with English law. Fast forward to 1965, during the before 1965, during what we call the federal government of Ian Smith. That was the amalgamation of Rhodesia, Northern Rhodesia and Nyasaland. We call it the federal government because a federation is an amalgamation of things. So the laws that were applicable were mainly Roman Dutch laws. That's why Zimbabwean laws are modeled according to South African laws, to Zambian laws. If you are a lawyer who practices law in Zimbabwe, you are also eligible to practice law in South Africa, in Malawi, in Zambia, because we use the same laws, except for customary laws which may differ here and there, but our laws are almost similar. You don't have to do another law degree. When you are someone with a Roman Dutch jurisdiction law degree, you shall be told about that when you progress in your lectures. So the laws that were applied during the federal governments were Roman Dutch laws. Remember, we are talking about development, so I am taking you through historical development of laws. Then after 1965, in 1965, we note that there was the unilateral declaration of independence by Ian Smith, in which Ian Smith declared himself independent from British affairs. He declared that Zimbabwe is now to be governed independently from Britain. That is the unilateral declaration of independence by Ian Smith. During the UDI government, we call it or refer it to as the UDI government. The laws that were used were mainly Roman Dutch laws with customary laws. Then fast forward to 1979, during the Lancaster House negotiations, there was a constitution which was crafted, because during the Lancaster House negotiations, there was a question of which laws are now going to be applied when Zimbabwe becomes independent. And people like Robert Mugabe and Joshua Ngomu opted that they should use the Lancaster House Constitution, though the Lancaster House Constitution is the constitution which was given birth to at the Lancaster House Agreements or Agreement of 1979. I think you all have constitution. When I'm saying the constitution, you should be aware of what I'm referring to. The constitution is the supreme law of the land. We refer it to as a charter. Yeah. If you go down the historical lane, you hear about the charter which Law Bengula signed. A charter might also refer to a constitution. I'm also going to take you through that. I've prepared notes which I'm going to give to you. So when Zimbabwe gained independence in 1980, Zimbabwe continued using the Zimbabwean Constitution, which was adopted from the Lancaster House Constitution, which is called the Lancaster House Constitution. So the Lancaster House Constitution was in effect up to the Government of National Unity in 2009. The Government of National Unity was between Morgan Tsvangirai and Robert Mugabe. The government extended from 2009 to 2013, but before the 2013 elections, Zimbabwe went into a referendum. A referendum is a yes or no vote, whereby people vote for something if they agree to it or they don't agree to it. So the majority of people, about 90%, voted for a homegrown constitution, which we are now using, which is the Zimbabwean Constitution of Amendment 2013 or Amendment 20. We call it the Zimbabwean Constitution Amendment 20 of 2013. We call it Amendment 20 because the Lancaster House Constitution has been amended 19 times. So the Zimbabwean Constitution is now Amendment 20. So in 2013, we adopted a new constitution, which we call Amendment 20, which we are using right now. I think you are aware of the constitution we are using. So before, you should note that section 192, which we are now using, or which your assignment question arise from, was formerly section 89 of the Lancaster House Constitution, which was adopted during the Lancaster House Agreements of 1979. So section, you should also include in your assignment that what we refer to as section 192 now is just a copy and paste of section 89 of the Lancaster House Constitution. Section 89 of the Lancaster House Constitution said that, or stated that, the laws that should be applied in Zimbabwe were the laws which were applicable at the Cape of Good Hope as at 10 June 1891. So when we adopted a new constitution in 2013, we incorporated the provision, but under a new section, which is section 192 of the constitution of the Zimbabwean Constitution. So it is another significance of section 192 that it is an extension or is an acknowledgement of section 89 of the Lancaster House Constitution. You can note it as point number 4. I think I am understood there. So that's how you can tackle the question. Let me repeat what I said. Section 192 is of significance because it officializes Roman Dutch law as our law. It helps us to trace back the historical developments of our legal system in Zimbabwe. It also helps us acknowledge customary laws in Zimbabwe and common law, which is unwritten law, which is universally applied to Zimbabweans. And it is also an acknowledgement of Section 89 of the Lancaster House Constitution. Let me see the notes which I prepared here. They are not written in any order, but you shall pick what you deem important according to you. Okay. Like I said before, the 10 June Proclamation of 1891 allowed the High Commissioner to respect native laws. Native laws will mean local laws. The native laws received recognition but did not get to be incorporated into general law of the country. We mean to say the High Commissioner allowed the colonizers to use local laws, which are now referred to as native laws, but they were not incorporated into statute books, or otherwise we mean they were not documented. Common law, that is the body of law which is universally applied in the society regardless of race, tribe or gender. It is unwritten law. Then what else do we need to look at? It's a historical overview which might help you in understanding the development of the Zimbabwean legal system. The Zimbabwean legal system is highly linked to the colonial aspects of Zimbabwe. So don't be surprised when I'm taking you down the history and the memory lane. On October 29, 1889, the date marked the commencement of the formal colonization of Zimbabwe. British South Africa Company was given a charter. A charter we mean a constitution by the British government. According to the charter, British South Africa Company was to rule in Southern Africa for 25 years before the contract was renewed. The charter was the first legal document to be used in Southern Africa. We should note that before the Lancaster House Constitution, the charter was the first official legal document which was used in Zimbabwe. So far Zimbabwe has been governed under the charter, the Lancaster House Constitution and the 2013 Constitution. You are tracing the development of the Zimbabwean legal system, right? So on 12 September 1890, the pioneer column arrived in Zimbabwe and raised the Union Jack. The Union Jack will refer to the British flag. That is the official colonization of Zimbabwe. Then on 11 November 1965, the UDI under Smith was declared. Under the Smith government, Roman Dutch law was applied. We are tracing the development of the Zimbabwean legal system. Then in 1979, the Lancaster House Constitution was drafted, but the section which was there, which is similar to Section 192, is Section 89. You should download the Lancaster House Constitution for you to compare the provisions of Section 89 of the Lancaster House Constitution with the Section 192 of the Zimbabwean 2013 Constitution Amendment 20. Okay. Then something you can also write about Section 192 of the Zimbabwean Constitution. It says that common law of Zimbabwe is mainly Roman Dutch law as per Section 192. Common law refers to unwritten law. Then when the section says the law which should be applied in Zimbabwe is the law that was applied at the Cape of Good Hope is subsequently modified, will mean all those changes which were effected to the Constitution of 1979, which is the Lancaster House Constitution. By modifications, we mean amendments. So you should note that the Constitution, the Lancaster House Constitution, was amended or modified 19 times before we adopted a new Constitution, Amendment 20 of 2013. Right. So for today I end here. For further question, I've given you my number. It's in the group. You might inbox me. I'm always free to attend to your questions if I have time.